I'm very pleased to be here to give you this opening address, and sorry that I'm unable to join you in Belfast in person. This gathering of national human rights institutions is an important precedent. The training and the focus on counter-terrorism is extremely valuable at a time when counter-terrorism law and practice is posing unprecedented challenges to the protection and promotion of human rights. As the United Nations Special Rapporteur on the protection and promotion of human rights while countering terrorism, I'm acutely aware of the political and legal challenges we face around the globe, and I'm also equally aware of the important and valuable role that national human rights institutions can play. Let me perhaps contextualize my remarks by putting some global context on our contemporary moment. I'll start perhaps with a historical look back to the events of 9/11, noting that as of those events, that terrible day this month, a number of things followed, and from a human rights perspective, those things, I think, frame the conversation and the training that you're having in Belfast. The scale and the scope of global counterterrorism threat was recognised on 9/11, and with it came an entirely new global architecture on counterterrorism. That global architecture sits in New York. It's defined by the role of the Security Council and, in addition, the important role of the Counterterrorism Committee, the CTED, the Counterterrorism Executive Body, and the newly created Office of Counterterrorism at the United Nations. All of these bodies put together play an important regulatory role in the regulation of terrorism and counterterrorism. But perhaps from a human rights defender's point of view, from the point of view of national human rights institutions, what's important to note is that this architecture, created and consolidated since 9/11, is an architecture that has been almost exclusively focused on counterterrorism, with no structural commitment to the protection and promotion of human rights. In fact, the architecture itself, in the immediate aftermath of 9/11, explicitly excluded human rights actors and human rights language from its creation. And it's really been an upward battle in the last 2 decades or so to ensure that we have some significant and sustained capacity in that global counterterrorism architecture to protect and promote human rights. My office is in fact one of those few pieces of the architecture that is specifically focused to addressing the relationship between human rights protection and security. I sit as one of the entities in the CTITF, and in that limited way have some impact, I hope, on the ways in which norms develop and the institution behaves. But that said, that global counterterrorism architecture is an enormous challenge, and it's a challenge at the national level because national human rights institutions like yourselves don't have a space globally to come and talk to when you are dealing with the challenges that you're facing in protecting human rights while countering terrorism. The second legacy of the 9/11 period, of course, is not just the architecture we have, but it's also the norms and the practices that have emerged out of that architecture. The norms, as many of you know, come primarily from the Security Council resolutions that have been passed since the events of 9/11. And many of those resolutions are in fact creating a new departure in international law and have significant implications for the protection and promotion of human rights. As my most recent report to the General Assembly, which is now available and circulating, explicitly addresses, the norms, and in particular the norms created by these Security Council resolutions, bear little or no attention to human rights and often function in ways that actively undermine the promotion and protection of human rights. In my most recent report to the General Assembly, I make a number of concrete recommendations to states to better promote human rights, to create an institutional structure that would be responsive to the human rights needs and demands in the security context, and that speak to the necessity of undercutting the conditions conducive to violence. These are the conditions that produce terrorism in the first place. The third global context that we're dealing with, other than the architecture I've described and the norm creation that has continued to accelerate since September 2001, is the human rights kickback or the backsliding, the regression that we are all experiencing globally. There are a number of things that many of you in the room are profoundly aware of as a result of that backsliding. The first is closing civil society space around the world. Increasingly, we are seeing all kinds of nefarious regulation by states which seek to limit the legitimate exercise of dissent, freedom of expression, the right to participate in government, and encroach on some of the most fundamental non-derogable human rights, all in the name of protecting security. That regression is also seen, I think, through the expansion in the use of emergency powers globally. And I would note that my mandate issued its thematic report to the Human Rights Council last March. And in that report, I detailed very specifically how we are seeing a new form of emergency regulation around the globe. And that regulation is essentially being normalized through counter-terrorism legislation. And what's unique about the challenges we're all facing is counter-terrorism regulation has two new faces. The first is that it's mandated by the Security Council, which gives states the perfect legitimate reason to say we don't have to take account of our domestic processes, and in particular the kinds of processes and protections that might exist at the domestic level to protect human rights. The second is that many states are going far beyond of what is required by Security Council resolution in their counter-terrorism regulation and using the requirement of regulating the very meaningful challenges that do exist to actually do other work. The other work is often to limit civil society space, to crack down on the work of human rights defenders, and to undermine the rule of law. I have specifically called on governments to recall their human rights obligations under international treaty law, and in particular to be more aware that counter-terrorism legislation constitutes a form of emergency power that must be regulated in the same way that traditional emergency powers have been regulated. And finally, of course, the context that we're seeing are repressive authoritarians. Authoritarian democracies and what some countries or governments have defined as illiberal democracies. These new forms of governments, again, are governments whose goal is not to uphold and expand the rule of law, but rather to limit it. And many of them use counter-terrorism and terrorism itself as the basis to do this work. For my mandate, I think there are a number of things that we're seeing that I want to highlight for this group. The first is that in the communications that come to my mandate as Special Rapporteur, I'm increasingly seeing the use of counter-terrorism law and practice against civil society. I would specifically speak to the experiences in Turkey, Saudi Arabia, and Russia, all of whom countries that I've engaged with about this issue as examples. We are also I'm seeing on a daily basis the practical effect of excluding human rights from global counter-terrorism regulation. And I think we're also seeing the undermining of national human rights protections through the use of counter-terrorism, violent extremism, and extremism rhetoric. So what's the role of national human rights institutions in the context of counter-terrorism? I think, and I've stressed, and again in applauding the gathering that you're having, I would underscore the importance of genuinely independent, Paris Principle compliant national human rights institutions, and more broadly of institutional space that promotes and protects human rights at the national level. But the key point, I think, in the counter-terrorism space is not just the existence of national human rights institutions, but their active and forceful engagement on counter-terrorism issues. They have to do very hard work. All of you have to do very hard work, which is in calling out and meaningfully holding governments to account, even when that work is difficult and strained. I would particularly speak to the importance of having within national human rights institutions, given the ubiquity of counter-terrorism regulation, both in exceptional law and ordinary law, ensuring that your institutions have the expertise that you need to address both the global challenges that are faced and the import of those challenges domestic. are imported domestically. It is also important that national human rights be increasingly aware of the ways in which counter-terrorism law and practice is being normalised as ordinary law. My own practices and what I would say is really important for me as Special Rapporteur, the countries I visit in which there is a genuinely independent national human rights institution, this is one of the first places I will go for advice and support. I think the expertise of these national human rights institutions is critical to helping special rapporteurs and experts like myself do the work that we do. I would also say that it is really important that when we are in country that we have the benefit of detailed, substantive and independent engagement by national human rights institutions. And in closing, I would also stress the importance for national human rights institutions of engaging with mandates like mine. We very rarely hear from you. We tend to hear from victims and individuals on the ground, but what we need is constant engagement and information from you. And for me, in the counter-terrorism space, we need the independent, robust assessments and analysis that you best can provide at the national level being transmitted and shared with my office. We need your help when we come on the ground, and more than anything else, a difficult thing to do, we need national human rights institutions to continue to hold independent space at the national level, to be forceful and strong advocates on the ground, and to do the work of defending those who are most vulnerable, and particularly those who are most vulnerable to abuse when states abuse their national security or counter-terrorism powers to do work which is not intended for those purposes. Thank you all. I hope you have a productive meeting in Belfast and enjoy your time in Northern Ireland.